Hello, this is Matt on the Moon Family Sedan channel. We got an unexpected filing by Ripple in the SEC v. Ripple case just yesterday, and it might come to pass that this will actually be the very last thing ever submitted by Ripple in this case. It's a supplemental filing, and we are so close in all likelihood to the end of this case, which is what leads me to say this. But I wanted to share with you this latest update. It's a pretty quick update anyway. I got a couple comments from individuals in the community on this, including David Schwartz. We've got some stuff from attorney Jeremy Hogan as well as attorney John Deaton. But before going further ado, to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And I will tell you, after covering this story for over 2 years now, it is kind of weird to think that what I'm covering right here, right now in this video, might be the last update before any sort of, conclusion to this whole train wreck. Get nostalgic about it. All right, so into this. Ripple has filed another letter of notice of supplemental authority to Judge Annalisa Torres in its legal battle with the United States Securities and Exchange Commission to support its fair notice defense further. Attorney James K. Filan, a defense lawyer and former federal prosecutor who has followed the case closely, disclosed this in a tweet yesterday, sharing a copy of the document. Notably, in the latest supplemental authority filing, the blockchain payments company cites Judge Michael E. Wiles' decision in the Voyager bankruptcy case to overrule the SEC's objections to Binance US's bid for Voyager assets. So, of course, I'm assuming that everybody's going to recall that Voyager is one of the entities that collapsed from the contagion that spread last year, and Binance US has now been seeking to buy these assets, and the SEC threw a hissy fit, and it didn't go so well for them. So anyway, check this out. Moving forward. Unsurprisingly, the latest filing has attracted a flurry of responses from XRP community members. Recall that, as highlighted in a previous report, Judge Wiles, in the recent ruling, bashed the regulator for fueling uncertainty in the nascent market. In other sections, the judge faulted the commission for failing to speak up earlier in the case, as highlighted by Ripple Chief Technology Officer David Schwartz in response to the latest development describing the SEC's actions as outrageous in 8 different ways in a follow-up tweet. The judge expressed outrage that the SEC would want to prosecute parties for carrying out transactions as ordered by the court. And folks, just think about this. Court says do something, and SEC wants to prosecute the people if they follow the court order. That's not a very good starting point, let's say. Piece continues. More so because the SEC's arguments as to why this could be the case were vague and lacking substance for the court to decide. It is potentially another situation where the SEC prioritizes its agenda over consumer protection. It requested the court to delay proceedings at the expense of consumers so the agency could form a position on whether VGX, which is Voyager's own cryptocurrency, just like Binance has their own BNB coin. But again, so it says here, it requested the court to delay proceedings at the expense of consumers so the agency could form a position on whether VGX is a security and whether Binance US is an unregistered security exchange. All the while, due to legal fees, the amount of assets users could recover would continue to decline. And the judge was not having that. And I was happy to report on that when that news broke, because people would be harmed, financially harmed, and there would be all this uncertainty hanging over their heads. And it just so that the SEC can, in theory, come to a conclusion that perhaps the VGX token itself is a security. And so then I want to get to what David Schwartz had to say here. He wrote to Attorney Filan on Twitter the following: "It's just the Department of Justice, in quotes, justice, insisting that they not be prohibited from criminally prosecuting people for doing precisely what a judge's order would compel them to do, despite not having raised any coherent argument that any of the order is illegal." Golf clap for David Schwartz. Yes, that's exactly spot on. And then there was this from attorney Jeremy Hogan. He wrote, "Ripple finally filed the Voyager bankruptcy judge's decision. The judge uses abnormally strong language, stating that the United States regulators themselves cannot even agree on what criteria to use in deciding whether crypto is a security. Fair notice. We are getting close. And so you might be asking, so how is this particularly relevant for Ripple? Well, attorney Deaton knocks this one out of the park. So here's a headline also from the Crypto Basic. Deaton explains potential effects of Ripple's latest filing in SEC case. And I think I wanted to jump down to, I think here. Here we go. Commenting on the filing in a Twitter thread yesterday, Deaton asserted that Judge Annalisa Torres could cite the recent ruling from her colleague in the Southern District of New York in a criticism of the SEC's actions and perceived inconsistent treatment of digital assets. Recall that days ago, citing the same ruling, the crypto law founder had asserted that judges would be forced to call out the commission for its perceived lack of allegiance to the law, overreach, and inconsistent statements. Furthermore, the attorney asserts that it is now more unlikely that the judge would rule in favor of the SEC in its charges against Ripple executives. Recall that the regulator had named and accused Brad Garlinghouse and Chris Larson of aiding and abetting unregistered security sales in its complaint. As previously reported, Deaton had labeled this move as a blunder on the part of the market regulator. Citing the latest filing, Deaton says it would be unlikely that Judge Torres would find the executives guilty if the SEC itself did not know that XRP was an unregistered security. And then they referenced the thread where he was citing the following, literally just yesterday. Attorney Deaton said, "I'm hoping Judge Torres was already very aware of the ruling by Judge Wiles of the U.S. Bankruptcy Court for the Southern District of New York, same district as Judge Torres, in the Voyager bankruptcy. Ripple offers the ruling in further support of its fair notice defense. If Judge Torres, in the ongoing working draft of her decision, criticizes the SEC's approach and inconsistent behaviors/attitude toward digital assets, she can cite to the Voyager ruling as further corroborative evidence of her criticism. I predicted over a year ago that Judge Torres will rule in favor of Brad Garlinghouse and Chris Larson. I believe Judge Torres will rule that no reasonable jury could conclude that the two executives were reckless in not knowing XRP was a security when the SEC itself didn't." Exactly. So it's spot on. And I know it's a little bit of speculation, but I think it's pretty healthy and reasonable speculation here that the judge might be writing something along those lines, criticizing the SEC because, look, she doesn't have a personal dog in the fight. And I've said this so many times, and it's certainly true here. Anybody who is unbiased and you got half a brain, you can see the inconsistencies. You can see the uncertainty in the SEC's approach to all of this. You can see all of the market confusion. So the idea that Judge Torres, who doesn't have a dog in the fight, not on a personal level, the idea that she'd come in and critique the SEC in such a fashion, it's not exactly a stretch of the imagination. And they should not. That was a blunder, charging Garlinghouse and Larson here. And so then you have, thanks to this Voyager case, Judge Wiles coming after the SEC, just berating them, and well-deserved. And now it leads to this situation where, again, made pretty damn clear, even the SEC doesn't know what the hell they're doing. So it's just a supplemental authority here. It's the timing couldn't have been better, frankly, because we're at the very tail end of the SEC v. Ripple case. So that was, like, on a scale of 1 to 10, 2 thumbs up. But it would be interesting to see when we finally get this decision handed down by Judge Torres, is that indeed going to be the case? Or we're going to be seeing language like that? Wouldn't be surprising. And then this is just one more source we can say, like, see, it's not just me, Judge Torres here. Other judges are coming to, dealing with SEC assets in other cases, and you can see that this is unfortunately becoming pretty clearly consistent in terms of their inconsistency. That's pretty much it. So it'll be interesting to see what happens, but we're about there. We really are about at the finish line, and I am ready for this all to be over. So who knows? I mean, unless the ruling takes a lot longer to, for Judge Torres to submit than we're thinking here, this might be the very last update I have from a legal perspective, for this case, in terms of new developments. This really could be it. But who knows? Other stuff could happen, and if she takes a long time to actually file this thing and it doesn't happen in March, and then, more time passes, the more opportunity there will be for additional supplemental filings like this one. So, I don't know. We about there, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.